additional factors to consider when setting child support in Texas. That is your topic for today. Welcome to the Lawyers and Mediators International Show and Podcast by instantmediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact dependent. Hey everyone, this is Mac Pierre-Louis, attorney, mediator, arbitrator, working throughout Florida and Texas.
This is Sherell Carter, attorney Sherell Carter, out of the Houston, Texas area, and happy to be here.
All right, Sherell. Oh, don't forget justicebycarter.com, the website you got to go check out. And Sherell, we're talking now about child support. And I have on my screen, split screen here next to us. If you're watching this on YouTube, be sure to go over to the statutes page that for section 154.123, labeled additional factors for the court to consider. This is on the screen as we discuss it. But if you're listening to this recording, make sure you can Google Texas Family Code Chapter 154. And if you scroll down to 154.123, that section, that's going to give you and fill you in with what it is that we're discussing today. So we're talking about additional factors that the courts consider whenever child support is being set. And let me lay the groundwork. So, Sherell, we do this every day. We go to court. We have parents who are either divorcing or separating. One parent is going to be named the primary conservator, and the other parent is a non-custodial parent, and that other parent is going to pay child support. Happens all the time around the country, around the world, really. And so in Texas, we have something called guideline child support, which basically is a formula that the legislature came out with that says how much money the non-custodial parent is going to pay for child support. And it's a percentage in Texas, different from other states. But in Texas, it's a percentage. One kid, 20% of your monthly net resources, two kids, 25%, and so on. All right. So here we have on the screen additional factors for the court to consider when the court thinks that the guideline child support amount that is set might be unjust or inappropriate. And so the court can go ahead and look at these considerable factors that the legislature has listed for them to consider. And they might then raise the child support amount higher or lower and not use the standard amount that might be pumped out of the calculator from the guidelines, but would instead make up a different number based on these other factors that they're considering. Okay. The one point I want to make is that we don't even need to discuss this or have any of this be considered by the court if the parties settle their case at mediation, or if the parties work their case out themselves and not even allow it to go. But let's say mediation fails, it's unsuccessful, and the parties are not able to make peace over this issue of child support. And let's say the parties just are unable to get this worked out between them and their lawyers, and this does make it before a judge. So let's go through these different factors, Sherell, but I'll let you take over and kind of talk about why is this even a thing that you wanted to talk about today? Go ahead.
Absolutely. So child support is always a big issue or concern when, parents are splitting or we're trying to find out what the best interest is for the child, right? Someone has to be able to provide for the child, presumably both parents. But there are some issues or some instances where maybe one parent feels or believes it's unjust, that they're maybe carrying more of the bulk, or maybe it's a situation where dad can't afford to pay what would be typical for guideline support. There are infinite ways to be able to rebut the presumption of guideline child support. One thing that is not listed here is if you don't have income. I'm not quite sure. Many people may not know this, that they can do minimum wage factors to establish of what the
Impute income.
income
Hmm.
should be. So that's also something to consider. Some people may not know that. But let's dive into some of these factors that can either sway for or against your increase or decrease in child support. So the first one we want to look at is the age and the needs of the child, right? Typically, we know that young children may require much more responsibility between childcare, diapers, the cost of formula has skyrocketed high. There are a number of things as to why maybe a child much younger may need more support than someone slightly in there, maybe say tweens, right? So
Hmm.
we will look at the different things and the needs of the child. You may have a child that is in competitive sports as opposed to someone who is not, right? There are a number of different things that the court can look at in regards to the child's age and needs that could help either increase or decrease the support obligations for one of the parents for the children.
Yeah, and in that first one, I'm thinking of some disability needs of the child. The child might have some special needs that is atypical with regards to other children. Um, but that question of needs becomes a big deal because I've seen lots of fights over one parent saying, "Oh, the child has that need," and the other parent saying, "No, that's a preference. I'm not paying for that."
Absolutely.
You know,
Absolutely.
so as far as the age, I guess I could go both ways because teenagers are really expensive, but you know,
Absolutely. And then getting into the disability, I mean, autism is very prevalent these days. Dyslexia, learning disabilities. There's a number of things that may go into play where a child may have to have, additional teaching and costs that come additional to what I would say the average child would be, exposed or used to. So who's going to cover these costs? Is it fair for one parent to bear the brunt of all the additional costs and needs? So these are factors that can be brought up and considered when we're looking at trying to rebut the basics of guideline child support.
yeah,
Another one of my favorite, is the ability for the parents to contribute to the support of the child. So this could definitely go either way for mom or dad, right? So we want to look at the parents' earning abilities. And when we're getting into section 154, 123, both parents' income has to be considered when we're looking at the guidelines for rebutting this presumption. But the ability of the parents to contribute, is it, we're looking at the best interests of the child. And sometimes parents equate possession with child support, or possession and cost, and that those two actually have nothing to do with each other, right? You want each parent to be able to have a solid relationship with their children outside of whatever the responsibility for the obligation for child support to come in. Is mom a registered nurse and has good hours, racking up great money, and dad is a custodian possibly at a school? Like, you want to look at some of those discrepancies to see where we can find a medium at providing an opportunity to rebut guideline child support, and that's one of the topics.
okay. Number three,
Any financial resources available for the support of the child. I also like this one.
yeah,
We were having a discussion on this, right? So what if dad is married to wealthy stepmom? Is the child entitled to some of those funds? Now, I don't think you can say, hey, judge, he's saying he doesn't have a job or he makes meager means, but he has a Rolls Royce outside. That obviously can't be considered. But we do want to be able to see the resources that are available, right? That have access to a certain amount of cash flow or a quality of life that the child should reasonably be able to have a part of. And that is where the availability terms come in for the support of the child, regardless of what the income that dad is stating that he actually has coming in.
yeah. That one's a big deal because people are always complaining about other monies that the person has access to. But I like to remind people that traditionally child support is based on income, right? Income being the key. However, income can take many different forms, including rental property income or
especially these
stock
days. Hmm.
annuities. So let's go to the next one, number 4,
Oh,
the amount of
time and
time.
possession and access of the child.
This
So
is a big one.
you want to speak on this one?
Yeah, sure. So one of the issues I see a lot is where a parent is paying guideline child support, but they don't come around and they don't possess the child when they have the time. The order, let's say, gives them a regular SPO, an expanded version of it, but they don't use it. Well, there is a disproportionate amount of time now that is on the back of the custodial parent. I have seen judges up the amount of money that the non custodial parent should pay because they are not utilizing the time and are not giving the other custodial parent any kind of break, because that does take a whole lot more resources on the custodial parent when the non-custodial parent is not taking the child away from them, because now she traditionally is responsible for that child 100% of the time. And so that's one reason why the court can consider whether or not and this is actually spoken in on another section in the law, but just letting people know that this is actually is a factor. And because of time, we're just moving on. We got about 10 minutes. Number 5.
Oh, absolutely. So the obligee's net resources. It also talks about if the obligee is intentionally unemployed or underemployed. Let's say uh, mom is living off just child support, right? She's not working or doing anything else. Like these factors can also be taken in consideration. The judges these days can make it, hey, go get a job. I've been seeing this a whole lot more. What about you, Matt?
Well, sometimes though these judges, in my experience, don't want to touch these a whole lot. So if you're going to go towards number 5 or any of these, you might need a lawyer to help you, because you need evidence. You have to actually show that, for number 5, for example, that the obligee is intentionally not working. So you have to actually bring some factors, so proof to show that the factors are alive and well and should be applied to the case. Because I think most judges would just like to keep things simple and do the guidelines and kind of rubber stamp an attorney general order that doesn't, um, consider these 17 factors. But it's there to be taken advantage of, and it's up to the party who thinks that guidelines would be unfair or inappropriate to bring up these factors. Okay.
Absolutely. Childcare expenses. Oh God, cost of childcare has risen drastically over the number of years. And here it makes a good point. In order for one party to stay gainfully employed, this is mothers. Some of you probably be able to have a good point on here if it's showing that the cost of childcare is $2,500 a month and you're making $2,000 a month. Is it advantageous for you to even work at that point, right? So
Yeah.
we would look at bringing in, obviously you don't just say it, this is, you bring in evidence, as Max says, in regards to showing that child care expenses, the amount of time that you're working, the time that the child is at the child care, in order for you to be able to be gainfully employed. If I mean, if these costs are astronomical, especially if you have maybe more than one child that is in the age range of needing child care, then this is definitely something that can be brought in to rebut the guideline child support to help you maybe get a little bit more than what's
Yeah.
standard.
Yeah. In the state of Florida, child care is already accounted as part of the calculation when you're considering what child support amount should be. Okay. So daycare is a cost that's factored into it. Texas does not count that. We simply look at the amount based on a percentage. So I'm actually surprised that this factor is not brought up more often. Now, maybe that has to do with the fact that a lot of moms these days can just go get NCI from the state, and that will give them credit to use towards childcare. But a lot of parents work, and I've seen some of these costs of daycare; they're really expensive. So that's a factor that I would say actually probably should be raised more, but it's actually not. Okay, number 7.
whether either party has managing conservatorship or actual physical custody of another child. So this is something that can be a bit controversial. We were discussing earlier. What happens if dad has a number of other children, right? Maybe dad is saying, "Hey, I my child support is too high for, this one child that I have with her. I have, three other children here that I'm also providing for." Is that something that can be accounted for, Mac? What do you think?
Yeah, and so that last part, or actual physical custody of another child, that is not specifically saying that the child of this case, if dad has other mouths to feed, look, judges are not heartless. They're not going to want to take so much out of the percentage of this one man when he has other responsibilities. And yeah, the other responsibilities might not be his kid. Now, as you know, you typically will get your credit for other mouths you got to feed, provided that those children are yours by a court order or they're living with you. However, what if they're not yours, but they're living with you because they're your other spouse's kids? Most of the time, don't even go there. Most courts are not going to entertain it. However, if it's something that's going to create an unfairness and an injustice, because applying the guidelines is just not going to work, then bring it to the court. And you never know, the court might actually buy it, but you have to show that this is actually going to cause a pain and an injustice when it comes to the amount of child support that should be, taken from the obligor. Okay, number
Okay,
8.
this one's pretty cut and dry, right? If
Yep.
one of the parties are paying spousal support or maintenance, and I mean, this is something you can take to the court and ask for consideration for a reduction in child support because you're already paying this additional amount for spousal maintenance in the one of the parties. So let's go to the expenses. We kind of touched on this when we were talking about too expenses of the son or daughter for education in secondary school. Let's say, I mean, there's so many when dealing with children. There's so many things that can come up. Even for college, like who has to bear the brunt of this? Is this all on just one child? In these days, right? We're even seeing kids graduating school like 16, 15, 16 years old and then going to college, right? So
Yep.
typical child support would end on a standard order when the child turns 18 or when they graduate from high school, right? But what happens when they graduate, Mac, and they're 15, 16 years old and they're going to college?
Yeah. So we all know typically this doesn't even become a discussion once the child emancipates from high school or is 18. The example you just gave about the 15, 16-year-old going to college, well, child support would still be applying because of the fact that the child's underage. But we never get to this discussion of whether or not college costs should be taken into consideration. But here we're allowed to. Here we can have the discussion about the cost of college, the enormous cost of college. As somebody who's taking student loans, I should know, and how expensive it is. And so if a parent is struggling to pay for their common child to go to college, that's a good thing. We want that, kids to go to college. Should that be taken into consideration as a factor to, reduce the amount of child support that parent pay? Yes. So the courts can, not always, but the court can, because this section is a may, consider the factor. And again, it's something else that you and your lawyer would have to raise to the court and bring it to the court's attention. Doesn't mean the judge has to go along with it, but it is a factor they can consider. Okay, number 10.
Oh, this was just straight to the point here. What if one of the parties has a vehicle that is furnished by their employer, right? Can you count that in consideration that they don't have to pay for a car note when you possibly do? Or maybe the employer provides their gas and, gas is expensive these days and you have to as the other party. So this is also something that can be consideration to either have child support increase or decrease in your favor.
Yeah, exactly. And one more thing is, and I know we're gonna go over in this segment because these are so important. I'm hoping that people will, watch this video and pause it on the section that they think might help them. But um, the two examples that come to my mind about this number 10 is the guy who gets um, a company car that is now of value that he gets to benefit from. And the mom's like, hey, shouldn't that be considered as income? Because that is replacing the cost that he would have otherwise to pay for another car. But he's not having to, he's getting that benefit. So that should be considered, that should be counted as income eligible for child support. So that's why the judge might say, okay, yeah, you're right. I'm going to go ahead and increase the child support he should pay, not just use guidelines for the actual cash he makes. The other thing is military and the person who gets the um, housing allowance. Okay, it
Yeah,
says it right
BAH.
there. Whether the obligor has an automobile, housing, or other benefits furnished by his employer. And so, if you're getting a housing allowance, and what did you say a second ago?
BAH, yeah.
Yeah, BAH, the basic allowance for housing, right? Um, that's money that's going to the obligor that they would never get otherwise, but they're getting it as, by virtue of the fact that they're with a certain employer, and therefore that is eligible for child support. But that's a factor people can consider. That's one example. Company car and housing. All right, number 11, the amount of other deductions from the wage or salary income or from other compensation of personal services of the parties. I almost never see this one come up too often, but um, if you look at your at the obligor's paycheck, then you can consider whether or not something is fair or not fair to be taken out. I think that should go for both parents.
Yeah, absolutely. Oh, favorite one
Okay,
here, number 12,
number
provision of
12.
healthcare insurance and payments for uninsured medical expenses. This is a big one, right?
Yeah,
I think I've seen in most standard order of possessions that maybe one parent would cover the cost of the child being insured, maybe through the employer, and then the rest of the expenses should be split 50-50. But I can say, how often does that actually happen? Right?
mhm.
I can think of the number of instances where I may have come across or dealt with a client that they may have this in their order, but are they actually getting the reimbursement for the other 50% of the costs? What would you say to this, Mac?
Yeah, yeah.
How
I
can we
think
help
if a
this
parent,
client?
if a child, first off, is sick enough to where you're always having, um, uninsured medical expenses, and one parent keeps footing the bill, and the other parent has a history of not paying it, I could see how that could be a factor for the judge to consider. Hey, listen, I'm gonna have to up your child support that you're paying to mom because it's just not fair. It's inequitable that we should just use a guideline amount because we need to account for these extra costs. So usually it doesn't need to be a factor because again, like you said, it's already addressed under the health insurance and dental insurance section of the law. However, this is something that can become a factor for the court to consider. Number 13,
Special
special or
extraordinary
yeah,
educational, health care, and other expenses of the party of the child.
yeah. This connect kind of back to the first one about the needs of the child, where if the child has extraordinary health care expenses, absolutely. I think on this list, probably the one that people think about the most is where the child has extraordinary health care. Most judges are going to think, you know what? Yeah, we're going to, you know, up child support based on this because of the child's best interest, and how it's not fair for it to fall on the custodial parent. What are your thoughts?
Absolutely, and like you said, I can mainly see that being the the healthcare aspect. But typically, if it is with healthcare, you're also going to see, especially if it's special needs, you'll see some increase in educational. Right, there may be additional testing that the child has to go through, special teachers, a number of things that the primary conservator has to deal with that maybe the other parent isn't, and those we want to make sure that it's an equal playing field, right? For both
Yep.
parents to be able to enjoy being a parent and providing for their children. So this is definitely a factor that we can bring in to, help with rebutting the guideline child support.
Yep. 14, three more to go. The
Oh,
cost
travel
of
costs.
travel in order to exercise possession of the child. Very
Okay,
popular one.
so right. So let's say here in Texas, everything is far. Everything is far. Ugh. So But what happens when, maybe one parent moves, or maybe it may be in the best interest to relocate for a particular type of school or activity? There's a number of things, but with that, one parent, right, has to spend additional money and costs to travel to exercise their right to be able to spend the time with their child, right? Should those costs be taken into consideration? And according to this standard, absolutely, the court may consider those additional costs in guidelines with in regards to child support, in regards to be able to help one of the parents to be able to exercise their right to be able to spend time with their child.
Yeah, the only time I see judges might kind of balk at that is if the judge is like, "Well, you're the one who chose to move," or something to that effect. But in my experience, most judges will give you credit. He just might not be happy about the amount of credit that you get when it comes to reducing the amount from the guideline amount. So it's one of those things. Just make sure you have your evidence and you can prove it. 15, positive or negative cash flow from any real or personal property and asset, including a business and investment. And
Hmm.
this is the one that where when I worked with Attorney General, I would hear dad say something to the effect, "Oh, I don't make the same amount of money every month. I sometimes have negative months." And one thing we had to always remind them about is not related to this is, well, that's why we use an average to calculate child support. And when you go further down, it talks about how child support, whenever possible, should be based on an annual picture to get your gross amount, then divide by 12, so you can get your monthly net resources, your monthly gross resources before the deductions are taken into consideration for the to get the net resources and the percentages applied. So we don't really get to this discussion if we're just doing the law of averages because we account for the highs and the lows in your income. You have seasonal work, we account for the highs if you're making a lot of money during the holidays, and you don't work when it rains because you're a roofer. We account for the lows when the we have some slow months in the rainy summers. But the point is, it's an average, so it accounts for everything. However, this is giving you certainty that, listen, if you can prove that there is positive or negative cash flow from any real or personal property and asset that's going to impact you in a really, really big way, that is not just income, then yeah, bring it up. You can bring it up to the court, and the judge can consider that as well as another additional factor. But you better be able to show that this is actually going to it goes to show that it's going to hurt or help. And I can see that this could work the opposite way, where the other parent can be like, I want to show that they have positive cash flow every month that nobody's considering as
You're gonna
income.
say, hey, he has 5 Airbnbs since then, right? So
Yeah. Yeah.
my child is entitled to some of that income, right?
Yep. All right. Number 16. Go ahead.
Debts and services assumed by either party. So we were talking about this in regards to possibly arrearage, right, in child
Yep.
support.
Yep. So
So
let's say let's say you owe back child support for another child, where that's a debt. And although that's not supposed to be taken consideration normally, because that you only get credit when you have to pay current child support for another child. But what about if the other child is grown and emancipated? Well, now you still have the debt that you owe for them. So the court can take in consideration any debt that you might owe. Um, that one I don't think is used a whole lot. But again, judges are humans. Judges have hearts, and they can consider this, and they can decide if they're gonna, you know, think that guideline amount would be unfair or fair. And
I can think of this one if you're going through a divorce, and let's say, you know, dad has agreed to take on, bulk of the debt, maybe credit card debt or loan debts or whatever. I can definitely see where that can be taken in
yeah,
consideration for, adjustment in child support.
absolutely. Okay, number 17, last one, that catch-all. Go ahead.
Any other reason consistent with the best interest of the child, taking into consideration the circumstances of the parents.
Yeah,
So, like he said, a catch-all. So this, I mean, this covers pretty much anything, right? So anything that's not listed in between the first 16, you can wrap it up in this one.
yeah. As long as it's consistent with the best interest of the child, that standard that these cases are reviewed under, by these trial courts. But again, guys, you do not have to deal with this list at all
at all.
if you are going to be able to work out a deal with the other parent. And the best way to do that is to go to mediation. And that's what
And,
instant
and
mediation is all about.
focus on agreed parenting. Do not let the judge decide your fate.
Yes, yes, yes. Okay, well, Sherelle, this was a good one for us to talk to folks, and we're gonna sign off. It took us 30 minutes to go through those, and if people have questions or whatever they want to connect with all of us, our websites are there, macplery.com and justicebycarter.com. You can check us out and ask your questions. All right, guys. Until next time, we're signing off. Hope this was helpful.
See you later.
Take care.